The justices weighed privacy against public safety, ruling that it's okay for police to obtain a sample of your DNA if you're arrested for a serious crime. Steve Flamish is here with more now. Good evening, Steve.
Jim, good evening. Many police officials call it the gold standard, swabbing a person's cheek to obtain a DNA sample, then comparing it to evidence in a database. In New York, it's legal to swab those convicted of a felony or major misdemeanor. But today, the High Court said just being arrested is enough. In a 5-4 decision, the Supreme Court ruled that police may legally obtain a DNA sample from anyone arrested for a serious offense. Writing for the majority, Justice Anthony Kennedy said taking and analyzing a cheek swab of the arrestee's DNA is, like fingerprinting and photographing, a legitimate police booking procedure that is reasonable under the Fourth Amendment. Rensselaer County District Attorney Rich McNally disagrees, saying that's not a fair comparison.
Hey, we fingerprint people upon arrest, but the thing to recall and the thing to know is that if you're never convicted, those fingerprints are returned to you, and they can't use your fingerprints to compare to other crimes.
The Supreme Court case focused on Alonzo King Jr., a Maryland man who was convicted of rape in 2009 using a DNA sample obtained years earlier. In the dissent, Justice Antonin Scalia wrote, "The court's opinion barely mentions the crucial fact about this case. The search here was entirely suspicionless. The police had no reason to believe King's DNA would link him to any crime." Michael Maycomber, an associate at the Albany law firm Tully Rinke, says the High Court's ruling hinged on whether the DNA swab is intrusive.
In the Fourth Amendment, it's unreasonable search and seizures. So it's not any search and seizure, it's unreasonable searches and seizures. And the Supreme Court's decision does a weighing of the search in this case. The Supreme Court came down on the side that it was not unreasonable.
But here's the big question. Does the High Court's ruling mean this will definitely happen here in New York? D.A. McNally and the governor's office say no, that it first requires a change in state law. But it is possible some police agencies may begin obtaining the samples anyway, leading to possible court challenges. Jim?